May it please the Court, I'm Joshua Gordon. I represent Steve Gubitosi, who could not be here this morning. Mr. Gubitosi was prosecuted by a replacement prosecutor from Belknap County after the Merrimack County's Attorney's Office faced a perception of a conflict of interest. By virtue of having been elected by the people of Belknap County, the Belknap County attorney has special status. She can appear in the name of those who elected her, and she and her deputies can put the state on the left side of the V. But once the deputy Belknap County attorney stepped over the county line, he became just a regular guy without any special status, without the weight of the voters behind him, and without the power to act in the name of the state. Under Martineau, a regular guy can't prosecute jailable offenses. Here it was not the state appearing in Mr. Gubitosi's case. It was Wayne Cool, regular guy. The remedy here is reversal, because if the error is merely harmless, there are two consequences. First, there would be no reason to comply with the temporary replacement statutes.
Well, isn't it a political question for the voters? I mean, if the county attorney does something like give up his power, maybe they'll vote him out of office.
I don't think there's a political question involved. I think there's the temporary replacement statutes, what you do in this situation, exist, and if there's no consequences to it, the courts will go on ignoring those statutes.
Doesn't the temporary replacement statute apply in a situation where the county attorney is actually away from the office for all intents and purposes and not simply disqualified from a particular case?
Well, I don't think so. The statute says becomes absent or incapacitated. The Superior Court can declare a temporary absence and fill the same for a limited period of time expressed in the appointment. Limited period of time, one case.
What does 7:33G mean then? Because the county attorney has the right to appoint a special counsel when the county attorney believes it is expedient to do so. So the argument is, I have a conflict of interest, therefore it would be expedient for me to designate a special counsel. Why doesn't that apply here?
Well, there are problems with that. And first is, from a preservation issue, just wasn't raised below, and the AG's non-pro-tunc affidavit is many years too late. But Wayne Cool, in his appearance before the Superior Court, didn't appear as a Merrimack County Special Assistant County Attorney like the statute would suggest. He appeared as Deputy Belknap County Attorney.
How was your client prejudiced?
My client is prejudiced because he was accused and tried by a person who wasn't the state. To the extent...
Can I go back?
Sure.
How was it that he appeared in the Merrimack County Superior Court? He didn't ride in there on his own. He was asked, wasn't he, to do that? Wasn't he asked to do it? The prosecutor.
The prosecutor...
From Belknap County was asked by the Merrimack County Attorney's Office to appear.
Yes.
So you said he didn't appear as a Merrimack County attorney. He isn't the Merrimack County attorney. He's from Belknap County.
Correct.
So his title is what you described, but he was designated as a matter of expediency, one would argue, to appear. So I'm wondering, why doesn't the statute pertain?
Well, my point is that if 733G were to apply, he would have appeared as Merrimack County Special Assistant County Attorney. That would have been his title. He never did that.
But the state never relied on that statute, the Superior Court.
Well, of course, the state never relied on that statute, and that's probably the reason he didn't.
The state says you never raised 661-9. That's not in the record either.
Oh, it's in. Mr. Gubitosi filed an interlocutory appeal, and that statute is cited and relied on in much of the same language that he did.
If the prosecutor had the authority, do you agree with that? The Merrimack County prosecutor had the authority under the statute to appoint a temporary replacement as a matter of expediency.
I think the Merrimack County attorney had the authority under 733G to appoint a special assistant Merrimack County attorney. Yes, I think that's true.
And doesn't it make sense, therefore, that if the whole office is disqualified because your client was a police officer in the county, it's the best person to select would be a prosecutor instead of some random lawyer?
Oh, absolutely. I think they selected the correct person. Mr. Kuhl had lots of experience with my client. He was participating in the investigation, tried the Belknap cases. They picked the right guy. They just didn't assign him. He just showed up. There was no...
But where is there a requirement in the statute that you have to, write it down and formally
In two
sign it?
places, it's RSA 733 and RSA 661-9.
If those statutes apply, I think part of our problem is we're not sure we agree that those are the operative statutes.
Well, 733G, the only other possibility, can't apply for the reason I've said. It wasn't preserved. He didn't appear as that. The Attorney General's supposed appointment came years late. But more important, if he were appointed as a special assistant Merrimack County attorney, whatever perception of conflict that applied to the Merrimack County's attorney's office would apply to him too. So I don't really think it solves their problem. The problem is easily solved by the Merrimack County attorney having filed a motion to fill temporary absence or a motion to...
Well, the question is...
But
the question is not whether it's easily solved. The question is, was the solution authorized by law, right?
Well, no. It was just done.
And what I'm having trouble with, counsel, is why. Because he didn't come in the courtroom and announce that he was specially appointed to the trial judge or to the jury? What's the mechanic that's missing here? Well, I don't see it.
Under either 733 or 661, the two slightly... 733 says the county attorney applies to the chief, I think the chief judge of the Superior Court. It says Superior Court as a body. In 661, you apply simply to the presiding judge.
No, I understand if there's going to be a replacement and the Superior Court gets to play, that's how it happens. 733G, the Superior Court's not mentioned. So if you say, I thought you said, yes, they could appoint someone as a matter of expediency, but he didn't appear as special counsel or whatever the proper title would be. My question is, where does the statute say, having been designated, you must announce your title to the jury or to the court? That's what I'm having trouble with.
Well, if he were appointed in the way, by the Attorney General according to 733G, 733G says, with the approval of the Attorney General, which wasn't ever happened, special assistant county attorneys may assist. Special assistant county attorneys. Presumably, if I were appointed a special assistant county attorney, I would write Joshua Gordon, special assistant county attorney, on my signature line, and that's how I would sign things. It's just not done. So it's apparent that this statute wasn't the one they were doing this under, and it's apparent that the other two statutes were also not being done under. There was no statute, no statutory authority was complied with.
What's wrong with the Attorney General approving it after the fact? I mean, that's what happened. You're right that the approval came some years or months later, but why does that make it unlawful?
Well, at the time of Mr. Gubitosi's trial, the person on the other side of the V there wasn't the state. If the Attorney General wants to pretend that it occurred ahead of time, I mean, really, that's a fiction. And at the time Mr. Gubitosi was tried, at that time, the problem existed. It was improper then. And to fix it later is really just a fiction.
Can I ask you, let's assume for a moment that the appointment was not done properly by statute. Where does it say that the Merrimack County Superior Court therefore loses its jurisdiction? If the prosecutor here is not a layperson, but a public prosecutor, where does it say the Superior Court would lose jurisdiction to hear the case?
Well, under Martineau, a regular person can't prosecute these crimes, right? And a regular person can't invoke the criminal jurisdiction of the Superior Court because they are just a regular person.
The argument would be he's not just a regular person. He's a prosecutor. He's a public prosecutor. As you would say, he's in the wrong pew, but he doesn't lose his status as a public prosecutor. So it is different than Martineau, isn't it?
Oh, I don't think so. He's a public prosecutor in Belknap County, or a public prosecutor in Nevada. You know, they're still foreigners as as Merrimack County is concerned, there's no mantle of authority from the people of the state of New Hampshire that flows through this man to become the state.
Can you tell me what was 733G designed to do? Give me an example where you say, in that instance, they don't have to go through the Superior Court to have an appointment made. Give me an illustration.
I think the example of prosecuting Richard Nixon, it's a special prosecutor when there are problems like this that require some sort of expertise or some sort of outside. Supposing there were an antitrust violation and nobody in the Attorney General's office or the county attorney's office had that sort of economics background, they might appoint somebody from outside or from another county, someone with that expertise, to prosecute that crime.
Can I ask you a question about the other issue on the statute? Is your complaint about the statute the word course?
Which statute?
The statute, the constitutionality of which you're challenging.
644-4.
Oh, you're talking about the
other issue in the
statute.
case, right? Yeah.
Okay. The harassment statute, my argument is overbreadth, and the purpose of the overbreadth argument is, the overbreadth doctrine is to make sure that speech isn't chilled. And
I understand your argument. My question is your complaint about the word course in the statute, that word is overbroad?
No. My complaint is that offensively coarse language, that phrase is, the entire phrase, not just the one word, is susceptible of too many meanings. I can call you up and say you look great. I can call you up and say you look great, but, with a lecherous wink in my voice. I can call you up and say you look ugly. I can call you up and say you look ugly, but with a playful tone. And whether I go to jail for those calls or not depends upon two things: your interpretation of the inflection of my voice and the inflection of my voice, and that sort of ambiguity in what constitutes free speech.
What would it have to say?
Is the problem.
What would it have to say to pass constitutional muster? If they were after the same issue here, how would they have phrased the statute that would accommodate the Constitution?
I think the other charge that Mr. Gubitosi was charged with provides the example. He called late at night in extremely inconvenient hours. I think extremely inconvenient hours coupled with offensive language, or the extremely convenient hours, the reason I'm not challenging the issue is people sleep at night, and presumably we deserve that quietude.
I thought he was charged under the coarse language.
In the charge I'm attacking, but there are others that are not at issue here.
Okay.
That charge for that.
Given the subsection B, repeated communications at extremely inconvenient hours or in offensively coarse language, you think offensively coarse language would be reasonably meant to be what you described to Justice Duggan? I think you don't look good, or that's extremely coarse.
I don't know. I don't know. And that's the problem. I don't know. It's obvious when it's such extremely coarse language. There is a point at which it's obvious, but there's a point at which it's not.
Where does the language come from? It's not a model penal code statute.
I don't think so. No, I think it's homegrown.
And what was the allegation of the language in this case, if you can say it without offending?
I don't really want to, but it was really terrible.
I mean,
You would agree that the language here is offensively coarse language?
Oh, I would agree that it's offensively coarse language. I think the jury could find that it was. The statute itself is facially unconstitutional.
Well, maybe or maybe not, but you would, if it is facially constitutional, you would agree that as applied to him, there's no problem.
I think the jury could have found that. Absolutely. I want to say one more thing on the wrong prosecutor. If Martineau is to mean something, that a regular guy can't prosecute these crimes, not reversing undermines Martineau. That means, it really means that Martineau doesn't stand for what it says it stands for. And it would also undermine the two legislative enactments. I ask you to reverse.
Thank you.